Good morning, Mark and Jordan. How are you?
Just great, Lena. How are you doing today?
Great, thank you.
I'm doing well. Just wanted to take a moment to introduce both of you, Mark Handelman and Jordan Eaton. I'll let both of you sort of introduce yourselves as well, but we do have the privilege of speaking with both of you this morning, and you're both renowned in your own areas of practice. So Mark, could you tell us a little bit about yourself and your practice and about Whaley Estate Litigation Partners as well?
Sure, Lena. Whaley Estate Litigation is a boutique law firm that specializes in estate litigation. So if there are disputes over wills or decisions for the care and well-being of an incapable person, then frequently the firm gets retained on issues like that. My practice relates more to consent and capacity work. I'm currently, for the second time, appointed to the Ontario Consent and Capacity Board, where we adjudicate issues of capacity under the Substitute Decisions Act and the Healthcare Consent Act. And I also know a fair bit about end-of-life decision-making. I do wills and powers of attorney for people, particularly of diminished or diminishing capacity, because apparently I know something about capacity to make decisions. So that's both the firm and myself in a nutshell.
Perfect, perfect. And you've been doing this for
too long.
Haven't you?
You're not going to ask that question, are you?
I know which questions to ask and which not to ask, but that's wonderful. I think that's going to actually come in very helpful for today's chat. And Jordan, could you tell us a little bit about yourself, your practice, Hull and Hall, for those people who don't know? I think most people do.
Great. Well, my practice, I've been doing this 25 years, believe it or not. I know that's impossible based on how young I look. But anyway, so I've been doing this. I draft wills and powers of attorney. That's really my practice. I'm counsel to Hull and Hull. They're an estate litigation firm. Again, they only deal with disputes, and I only deal with matters that aren't yet in dispute. Hopefully they won't be in dispute. And I take great pleasure in saying that I'm a professor at Osgoode Hall Law School, and I get to teach first years law students, which is lots of fun. And yeah, so that's what I do.
Wonderful. So Jordan, since you're actually part of the initial process when a client comes in to have their estate documents drafted, I think I'd love to ask you first, in the context of coronavirus and certainly the recent emergency order allowing the virtual witnessing of wills.
Right.
What are the main things that you've seen change in your practice? I mean, this is really, we're talking about the last couple of weeks.
Yeah. So certainly remote meetings for gathering instructions. So when you're planning a will, we as lawyers need to gather information about the client's biographical situation, their family, as well as their assets. So gathering that information and then meeting with the client virtually using, for example, Skype or Zoom or one of those conference technologies, where we can see each other, communicate. It's not quite as good as being there live, but the other thing that I use is technology to graphically represent the plan live. So as the client gives instructions, they are seeing the impact of that in a graphic form. I use software that I help develop to do that. And that's really a boon when we're stuck working at home, to be able to see, for the client and for the lawyer, to see what am I saying again? So you keep track of what you're doing. And now with virtual signing, in essence, signing by remote conference, we're seeing basically from start to finish being able to do it all remotely.
That's wonderful. I know, when I've drafted wills over the years, I've often found that visually representing, especially, how shares are being broken down to given beneficiaries have been extremely important, because people, not everybody, but a lot of people, and certainly myself, maybe I'm biased, tend to be visual.
Everybody's visual. I've yet to find somebody who prefers words to a picture.
Only lawyers usually, I think.
Right, quite correct. And that's why it's tough to get us to use pictures. But yeah, I mean, I fully believe in visualization to keep track of instructions and the impacts.
Could you give us an example of that? I mean, I'm digressing a little bit, but this is fascinating stuff. I used to sort of just
Well, let me demonstrate.
Charts. Let's see. Okay.
So this is what a client would see as they're drafting the will. Now, this isn't the greatest. I bet if I could share my screen, I could show you a little bit better, but
Yeah, go ahead if you like.
okay, great. Let me do that. That was a little lower tech.
It's okay. We're at home.
Okay.
We're trying to find technological ways
let me
drive
show
the
you.
industry.
Maybe we can edit that part out. But I don't know if you guys can see this.
Yeah, I don't think you should be using that, Jordan. We've got client names on it.
No, those aren't real clients.
Oh, okay, good.
So
Was I supposed to ask that question?
no, that was okay. But this is what I give to the client at the conclusion of the meeting. The client can see, okay, I always describe a will like a funnel of all your assets that come in. And then we have filters for debts and taxes and specific gifts. And then the balance, the bucket at the bottom, which in this case, the client can see, yeah, it's going to my kids, but it's going in a trust to age 30 with 25% at 25.
Great.
And yeah, and that's, and basically you can drag, the software I use, for example, you can demonstrate to the client the impact of different decision-making.
Oh, very nice.
And the taxes saved and all of those things. And the client can see what's going on. And I believe that this is the way to have a useful meeting. We're on the same page quite literally with the client, and they can see, oh, if I don't give the RSP to my spouse, oh, I'm going to trigger a whole bunch of tax, or I'm going to trigger probate tax or whatever it might be. And so that's really, I find, really, quite frankly, the only way you can have one of these meetings is to do it in a visual way. And then the client gets to go home with something at the end to say, yeah, this is what my will's going to look like,
That's wonderful.
And so that's how I used it.
And I guess you can play around with the fields. For example, someone who's 50 years old might say, look, my estate is worth X right now, but I anticipate living.
Absolutely. You can add future assets in here.
Beautiful.
And you can, you can do all of that. And the client gets a real sense of, after giving away all these specific gifts, what's really left over, because often we don't talk about that.
Oh, that's really great. So Jordan, you are essentially really set up to be able to do this virtually. I think you're ahead of the pack in terms of where a lot of lawyers were at, because this kind of came out of nowhere. I mean, right now I'm sitting in obviously a different location than you are, and I'm able to see this as well as I could on my own screen. So I assume you can do the same with your clients.
That's exactly. As the client, we sit down with the clients, literally, they're sitting down, and I say to them, okay, what do you want to do? Let's talk about your cottage. Well, okay, yeah, I want to leave that to my kids. No problem. Let's leave it to our kids. But don't forget, there's going to be some tax implications there. And, there we go. And now the client can go back and forth and see what we're doing. That's
very nice. That's great. And you developed this yourself, I guess, with a development team?
Yeah. So this is called eState Planner, and Ian Hull and I created this, and we now have, I'm glad to report, 130 firms who use this. And
very nice.
Yeah.
I'm impressed. I think it's useful. It's hard to keep track, especially if some lawyers, math might not be their strong suit. They can be great at drafting.
That's why they went into law, right?
Yeah.
They'd be doctors
Exactly.
otherwise. Right?
This is a great set of second eyes, I think, when they're trying to, figure out the various implications of different decisions.
Yep, that's how I feel as well. And you don't make mistakes. You don't make as many mistakes for sure with using this kind of software.
No, that's great. So in the context of sort of, the recent changes that have been happening, I mean, I guess I'd ask Mark, you as well. Have you noticed any major changes in your own practice?
Well, yeah, there's not as much of it right now because most of my practice involves wills and powers of attorney for people of diminished capacity. So previously I spent a lot of time going to nursing homes and hospitals and retirement facilities to receive instructions and to prepare the documents. And by the way, because of the nature of that sort of practice, I video record my interviews with clients, and I save the video as a permanent record of the interviews. Of course, I get permission from the client to do that, and then when we come to execution, I get permission from the witnesses as well. But I don't think anybody can take notes as well as a video can record the nuances that happen. And sometimes capacity to do a will or a power of attorney is nuanced. I mean, just because somebody has a diagnosis of dementia, or for that matter, the coronavirus, doesn't mean they've become incapable overnight. It means that they are beginning to become incapable. And somewhere along that trajectory, somebody realizes, oh, Dad needs to change his will, so call Mr. Handelman. I am using video technology now where that is feasible. The frustration is not a lot of people in nursing homes have the time right now to sit down with one of the residents and help them set up a laptop and a video recording situation, because a lot of the people for whom I have done wills and powers of attorney are just not able to figure out the technology, in part because of diminished capacity, but also in part because they have gotten on in years and computers are generally foreign to them. So that makes everything a little more difficult. I mean, it is still possible, it just takes more planning and more effort to get it done right.
Mm-hmm. That's a great point, because I know for us at Access Law, those are the types of things we've been trying to help people with recently. So to touch on your point about recording sessions and ensuring that it's a better memory than your own memory, we found that we've been recording all of our video sessions for about 1.5 years now, just because, particularly for any type of contesting of wills. We have a recording, we have it backed up. I'd love to hear your thoughts on that, but maybe in a moment. I found that has been really helpful, not only to have a record, but I find that when people know that they're being recorded as well, they tend to, be a lot more clear, and it closes the door on a lot of frivolous issues that might come up in the future as well. So have you found any specific way to get around issues where there are clients that are either in the hospital or in a home and are just intimidated by technology? I mean, it could be very easy technology that you could access with the click of a button, but they just are intimidated by it and they don't want to proceed. We've had a lot of issues with that. That's the reason I'm asking.
I've not run into people who are intimidated by it doing it remotely, because frankly, it is not the client right now who is doing it. It is a family member or a staff member at the facility who's setting it up, and then making sure the person is in the right place and can be seen and doesn't knock the machine over or things like that. So I'm not having that kind of a problem. The problem is, why aren't you here to see me in person? And that is for people who don't currently have the ability to understand the depth of the pandemic and the extent of self-isolation. And, you know, I'm dealing usually with elderly people who came from another generation where everybody was more genteel and where things were done in person and you did not have video meetings. But then after a few minutes of small talk, people tend to forget about that sort of thing and hopefully get engaged in the process. And they're talking about things that are important to them, and they're talking about their family. And at some point that usually overcomes the fear of video. So
building the rapport, really,
exactly.
To kind
and
of break
you
the
have
ice.
to spend a few minutes extra doing that. I mean, all three of us are lawyers. We know what it's like to have a new client come in to talk about things that are intensely personal to them. And you need to break the ice for a few minutes. And it just takes a few minutes longer to break the ice when somebody's looking at you on a laptop instead of across a table.
Exactly. That makes a lot of sense. Now, this current emergency order that was brought about a couple of weeks ago, it's causing a lot of ripple effects across the industry. I know what I've been hearing a lot of from various lawyers is, look, this is a wonderful initiative, but I don't practically know what to do with this. I now have to, courier documents a bunch of times, or have to sort of jump through hoops to be able to use it. I know that we're using it. It's not quite as, seamless as it might be, but I'm curious how, Jordan, Mark, how do you feel about the current emergency order? Do you think it's helpful? Are you using it yourself? Have you come up with any strategies to sort of streamline the process?
I'll just jump in here.
Go ahead, Jordan.
If you don't mind. Yeah, so I have used that. The process, and it does require a courier. I happen to have my son who's 21, so he can be a witness. He's over 18, and so it only requires one courier. I think you're going to see change shortly. Let me just leave it at that to make things a little bit easier. I think you'll see a way of doing it in such a way that that we won't need that. That's my.
I like where you're going with that. I was actually going to ask next about whether you think there should or there will be permanent changes to legislation such that, the Succession Law Reform Act is changed, or even the emergency order. Maybe I'll just skip ahead a couple of topics. We can contrast this quite nicely with what's happening in New York. Are you both of you familiar with the emergency order that was put into effect in New York State?
Not familiar, Lena.
Jordan, did you?
I was sent the draft of that order, which is a lot broader than Ontario's order. But yeah, so.
What I think is, it's, I always like, sorry, go ahead, Mark.
Yeah, thanks. Lena, this was a first order that had to get pulled out of somebody's back pocket in a hurry. And
yes.
It is not perfect, but it is certainly a step in the right direction. And I expect that that the legislature will revisit this topic. They will get feedback from practitioners. They'll understand the parts that are practical and the parts that are impractical. And when government has a bit more time to address its mind more fully to this issue, I think we'll get a better result. But the other aspect of that right now, though, is they had to do something, because somebody who finds out that they're on the way to hospital with something potentially fatal might want a new will or a new power of attorney. And so at least we've got something to work with for now. I think the government did a good job of producing this almost immediately upon the requests from practitioners like yourselves, and it will get better. And just by the way, I think it's not going away for the foreseeable future, at least until there is a reliable vaccine for COVID, because I would not want any one of the three of us visiting my mother or my grandfather in the next couple of years if there's the risk of infection, let alone the risk that the practitioner faces by going to see somebody live and in person. So this may be the new normal for 5 years or longer.
I think that's a good point. And I have to say, I have been very impressed with how quickly the Attorney General's office has acted in the face of what's going on here, even prior to the coronavirus becoming, what it is today. I found that they have been very receptive to change in the legal industry. I mean, you guys know what's been happening with, the virtual commissioning and notarizing. And the fact that they've stepped up and really made these decisions quickly has been wonderful. So I love what they've put into place. And I think what I always do is I always like to look at how other jurisdictions are doing it and saying, okay, now we have something in place. Is there a way to tweak it? So New York, which I referenced earlier, their order is only effective for 30 days. I think they put it in place for 30 days, 31 days, something like that. And again, I think that's just because they had to do something quickly. But what's interesting about theirs, and something that, maybe we want to consider doing in Ontario, and I'd love to get your thoughts on this, is I'm just going to read quickly their requirements because they're interesting. So the first thing is The ID has to be shown on the call. It can't be sent, I mean, it can be sent before or after, but it must also be shown on the call. There has to be, as we do, direct interaction during the call. So it can't be, me signing the document, recording it, and then emailing it over to you to witness. So there has to be direct interaction between the witnesses and the testator, or theirs also applies to power of attorneys. A witness has to receive a copy of all of the pages that have been signed through email or fax or whatever means on the same day. Now, the interesting one is this one. The witness can sign the electronically transmitted copy of this signature pages and send it back. So that's a little step further than what we're doing. So you could sign over wherever your house is, sign it, email it over to me as the witness, and I could actually sign that soft copy page, send it back to you. Now we have something we could use. It looks like what they're doing is they're also doing hard copy wet ink executions as well, because the order allows then for you, after we've got this executed copy, for you to take your wet ink signature copy that you have at home, courier it over to me, and I can now witness it as of the execution date. They allow you to backdate it as of the date, which is nice because now you have something that's in effect the same day that it was signed, but you also have a nice wet ink signature, which I assume is probably just going to help jump through hoops if it's needed for probate court.
We're gonna have.
Sorry.
We're gonna have something like that.
Nice. Okay, so that's,
yeah. Without,
Lena,
yeah, I think we're
quick,
going to see that.
Just a few quick comments about the whole thing. Now we've added the extra layer of paying attention to the video recording. That doesn't take away any of the other obligations a lawyer has in the preparation or execution of these documents. You still need to pay attention to capacity. You still need to pay attention to the risk of undue influence and little details like that. And so you may not be in the same room as your client, but it's not a bad idea to ask the person to spin the camera around so that you can see that there is nobody else in the room giving hints from the corner or something like that. All of the regular obligations remain. And something else that I think is important is a fresh affidavit of subscribing witness by video execution. I think we need to identify that we've done it this way and why and exactly what the steps were in the process, just to make sure that there's no issue down the road. And
we developed an affidavit of execution by video, and on the Hull and Hall blog, there's a whole article about affidavits of execution under these circumstances. Yes, it's going to be crucial.
I think you've hit most of the big issues on the head. We also use an affidavit like that. I've taken a look at yours as well, Jordan, and it's excellent. It'll be interesting to see when these wills are probated if there are any issues, but I feel that the courts are going to be hopefully a little bit open-minded and lenient, not send back applications if they're missing a period here and there, which is sometimes the case with some courthouses.
Yeah, they're gonna be relaxed, but I think the more there's strength in numbers. So yes. I think the more people who are, because of course it's not a court forum and we don't have that right to do it, but the more people who stick to the more people use a standard form for the affidavit of execution, the better it is. Even if you you might like the word, and instead of the, go with make it look at least pretty much close. That would be my hope for people. But anyway.
I think that's a great point. Mark, I just want to touch on a couple of the things that you mentioned, because we've identified sort of the same things right now. When even over the last, I think, year and a half, when we've been doing virtual appointments, we couldn't do the virtual signing or witnessing. We would always take the camera and do a 360 of the room. It's not foolproof, but I think it's a nice step. What are, in your mind, with sort of the current situation with how wills are being done, what are the big risk factors? Are there any major risk factors that you haven't outlined already that, lawyers should be aware of, or as a profession, we should be aware of and we could try to find solutions for?
Lena, the risk factors are the things that we haven't thought about and won't think about until they actually happen. People are round pegs and all the holes are square. And it always amazes me, and not only in this context, but generally, it always amazes me how imaginative people can get when it comes to not intentionally, but unintentionally circumventing the law or making a mistake. I mean, that's why we have litigation of any sort, because somebody does something and breach a contract that nobody anticipated. So we've covered the major concerns here, but I have no doubt that something will happen one day, and the three of us will sit here and say, there but for the grace of God could have gone I. And I really hope that the three of us all get to say it rather than me getting a phone call from any member of the firm to which Jordan is counsel saying, Mr. Handelman, you messed up a virtual will. Or by the way, Jordan, vice versa.
Yes.
I'd hate him to have to call you and say the same thing.
I hope, I dread that day, of course, but I think that, virtual, I also use virtual, I've used virtual meetings because many times we can do most of it that way. And I do record that. And the great thing is you can replay with this software, you can play the process that we went to and basically see the whole discussion about why decisions were made. And I think most risks to wills are not that somebody's got a knife in somebody's back, but that the client didn't understand all the implications. That's 90% of will challenges are based on that, not undue influence. And capacity fits into that, of course, the ability to understand all of those things. But that's why I believe visualization is so crucial, because it's much easier for clients to understand it and for us to support the argument that they understood it.
That's a great point. That's a great point. Now, I guess I would ask, in a perfect world, where would you like to see this go? Would you like to see permanent changes to legislation? Do you think, setting aside the current reasons that a lot of people are doing it right now virtually, do you think it's a good idea? Would you like to see the doors open and allow for more of these type of activities?
Well, I think we have to. It's just that simple. The law has to keep pace with an ever-evolving society. We have inadvertently and without forewarning been thrown into this as a result of a pandemic, but there will always be people who would rather not try and get to a lawyer's office, lawyers who won't go and visit their clients at home or in nursing homes. But as I said before, it's going to be a few years before any of that becomes safe again. So refining the current provisions, in my view, would be a useful process. Great.
Jordan, any thoughts on this, or are you you have to keep tight lips on this one?
No, I would just say, I do believe that we're going to have amendments down the road to the Succession Law Reform Act. This is 200 years old. Our manner of execution hasn't changed 200 years. It's going to change, I'm sure of it. When it's not a huge priority usually for governments, so that's the problem. But I do think we'll see that. And yeah.
A client asked me a few months ago, before we hit pandemic, why he couldn't do a holograph will typing it out on his laptop, which in his view is the same as writing it out by hand in the 21st century. I didn't have a good answer for him.
We've had the same type of inquiries. Yeah. Last question I've got for both of you. I know there are still some lawyers, some corners of the industry that are really opposed to not necessarily virtual meetings, but certainly virtual witnessing, virtual signing, anything sort of in that arena.
Lena, there are still some lawyers.
Where that's coming from?
There are still some lawyers who are opposed to the ballpoint pen and insist on using quill and ink. So what can we say about that?
I would say this, that if we as lawyers don't change the way and we hit the nail on the head, we use words, we only think that's the way to communicate, and it's not the only way to communicate. We need to, as lawyers, adapt to this changing world. And if we don't, we're going to have real problems. And our clients will too.
I couldn't agree more. So for any lawyers out there who want to help push change, who would like to be a part of sort of a movement where we can be a leader in the legal world rather than, somewhere in the middle, sometimes a follower, do you have any recommendations? What could they do? People who want to get involved, people who'd like to push.
I think you start with your member of the provincial legislature and you write a letter and you say, thank you for the good job the government has done in allowing us to do virtual witnessing of wills. Will this be continued? When will there be amendments to the Succession Law Reform Act, the Substitute Decisions Act, and other necessary pieces of legislation so that this can happen?
Mm-hmm. And what do you think about the strength of petitions? I know Patrick Hartford of Notice Connect had sent around the petition requesting to change the SLRA a few weeks ago, which I personally thought was a great idea. I shared it with everyone in our firm, anyone who I thought might be interested, and I asked them to jump on board if, of course, they were aligned with the ideas. Do you think that if we, if we had petitions targeting very specific changes and we had enough licensees sign on, do you think that that would carry a lot of weight?
Well, shouldn't the Law Society be helping us with this? I mean, we are.
Oh, certainly.
And I know that their job is to protect the public, but lawyers are members of the public as well, and this is for everybody's benefit. I'd like to see the Law Society take the lead on this, and I'd like to see the government strike a committee of people with some experience in this field to figure out how to get it done the best way possible. Mm-hmm. Which, by the way, those meetings will be not in person either these days.
That's true. And, one thing I've really been impressed with in terms of our current provincial government is just their ability to reach out to people in the profession, to put together working groups on these types of issues. I like the fact that they are taking a very proactive role. Completely agree with you. The Law Society is sort of should be in a position where they're taking a leadership role too. And, I hope we see that happen. For those of us who are a little less patient, are there other, avenues that you want to sort of push? Just people need help today. So yeah. I think we can all kind of put our heads together, but that's great feedback. Anything either of you want to bring up, anything that we haven't touched on today that you think would be interesting, helpful at all?
Yeah, I've got a pet peeve that I raise every time we talk about wills and powers of attorney. The power of attorney for personal care is not an add-on, oh yeah, I did one for you. It is a vitally important document. It needs to be thoroughly explained to the client, and if there are going to be wishes relating to treatment or end-of-life decisions, those need to be discussed in detail. On my end-of-life litigation practice before I rejoined the Consent and Capacity Board, the usual problem was nobody talked about those things. So this is a vital conversation, and the power of attorney for care is a vital document, and lawyers need to pay more attention to it.
That's a great point. That's a great point. We're seeing a lot of people, particularly now, in a position where they don't have those documents. And if they do, exactly like you said, they may not have been explained thoroughly or properly. And now sometimes it's too late. They're in the hospital and either they can't have access to the person they want to appoint, or any number of issues, right?
Exactly.
Mm-hmm. Okay. Jordan, anything else from you that you wanted to bring up?
Just that we as lawyers have to adapt and adopt new technology and jump in, invest some time in it, because just like you go to CLE, invested in technology, it will make your life better. It will make you more efficient. It will make your clients like you better, and it will make your practice safer.
All of
Great points. Great points. Thanks, guys, so much for taking the time today. Really wonderful to get both of you speaking with me at the same time. I think it's these kind of dialogues that are necessary to push things forward and come up with new ideas. So thank you very much for your time. Enjoy
Thank you.
from home. Be safe, be careful, all that stuff.